On this record, as you can see, as of August 31st, 2023, it states the amount of child support arrears is $170,000, $170,004.36. Does this accurately reflect the amount of child support arrears owed to you?
I believe so.
Did Mr. Vu give you child support cash to you in your hand or otherwise, which would make this amount lower?
No.
Are you asking the court to enter the qualified domestic relations order for the amount of $170,004.36?
Yes.
Mr. Vu, as shown on the screen, as of October 31st, 23, does the $170,004.36 accurately reflect child support arrearage owed to Miss Vu Johnson?
No, ma'am.
And why do you believe it does not accurately reflect child support arrears?
Because I paid direct payments starting from I want to make sure I give you the correct date, October 2008 in the amount of 900 all the way through to March 2017 when the OAG filed the wage garnishment.
What
So
amount
total,
did you say? You said the amount. I can't remember the number. Was it 800?
900, ma'am.
900.
How did you allegedly make these payments?
I paid it as a check payment every month that my son would provide her. I've got a couple of stubs. One of the things I've been trying to do is I've been trying to contact my bank to go all the way back to get copies of the stubs, but they haven't. They're telling me unless I file a motion, they won't grant that because it just goes too far back. But I have examples first started.
Well, do you have copies of how many payments are you saying you made? 100? Did you make 40? How many exact payments did you make?
Yes, ma'am. So 91,800 divided by 900. Let me do the math real quick. 102 payments, ma'am.
All right. So are you saying that somewhere you have or can obtain 102 canceled checks for $900 each?
Ma'am, I don't have physical copies of 102. I have a couple of examples that I kept, and I tried to get the bank to provide me more, but they weren't able to. I can upload a few examples if you'd like.
Well, I've my next question, sir, is have you contacted your pension company, Chevron Corporation, to discuss this with them?
Yes, and what they've said is it's up to what the Quadro says, what the outcome of the Quadro is.
All right. Nothing further past this witness.
I find it interesting how she is hounding him to show proof for over 100 payments dating back years, yet didn't ask the wife who's claiming she never got the money for any proof that he never paid.
Your Honor, I'd also like to see if I could get, if there's any way I could get credit for the fact that my oldest son lived with me since 2011.
May I call Ms. Johnson, Your Honor?
Did you hear his last statement, Ms. Hernandez?
He's saying that one of the children lived with him. So I'd like to ask Ms. Johnson if this is accurate, or,
Okay, you may do
No, Your Honor, that is not accurate.
Ms. Johnson, okay, so did you relinquish custody of one of your sons to Mr. Vu for an extended time, longer than 6 months?
Yes, for longer than 6. After Hurricane Ike, when we were going through construction here, he did stay with Doug, but he was a latchkey kid. And then before he graduated, before he finished high school, he was kicked out of his father's house, and that caused us to find Nathan a place to live. I talked to the counselor and told them the situation. He was at risk of not graduating. And that's when I went to the state to complain and let them know that he had been paying his child support. The only evidence that I have is the only evidence I have is the divorce decree, the original divorce decree, where I followed everything to the T. He did not. I kept my kids insured. I took them to all their doctor's appointments. I provided him with all our information. He denied me his information. When he left his employment, he didn't notify me. He didn't give me his change of address, any of that stuff. Everything here, everything, the original divorce decree.
So her proof that he owes her $170,000 is the original divorce decree. I wonder how much she thought that one through, because she clearly doesn't realize how ridiculous it sounds.
And when you say your son went to stay with Mr. Vu, was that because of Hurricane Ike damage to the home or something?
Yes, ma'am. Yes, ma'am. And to this day, we're still making repairs, but it
Okay.
was within that
No.
period where
Okay.
we had no.
Objection? Okay.
Sustained. Okay, everyone.
The first check, when was it written?
October 2008 in the amount of $900.
Now, the second check that I'm showing, it was written November 20th of 2008, correct?
Correct.
And it was in the amount of $900.
Yes, ma'am.
The third check that was written was December 20th of 2008 in the amount of 900. Is that correct?
Yes, ma'am.
Fourth check is January 20th of 2009 in the amount of 900.
Yes, ma'am.
Fifth check, December 1st, 2016, the amount of
Yes.
900.
It wasn't the next check that was paid. It was, these are only this is only the checks that I can get from the system because they're only obligated to hold 7 years back.
Okay.
I wasn't able to retrieve it all.
Now, and the checks that are shown here, this is a check from January 1st, 2017 in the amount of 900.
Yes, ma'am.
And then February 1st, 2017 in the amount of 900.
Yes, ma'am.
The last check shown here is March 1st, 2017 in the amount of 900.
Yes, ma'am. And then after that, the state did the garnishments.
Okay. So you have, as an exhibit, 8 checks in the amount of $900 to prove that you paid that directly. Now, was the intention for these checks to be paid for child support specifically?
Yes, ma'am. And I recognize that it was for whatever the difference of $1,398 minus 900, and I recognize those are arrears that I do owe the difference.
Okay. Do you know, only if you know, do you know if Ms. Vu was aware that your intention was to pay the child support with these checks?
Yes, ma'am. As they were written on under the memo statements, and they were accepted every month.
How did you express your intention that these checks were specifically for child support?
At the time when I started to make the child support, those direct payments in March of 2008, we had a conversation, and I said I will owe you the arrears once I get back on my feet from the failed business, and so that's what was discussed, and I did it directly, and that's what we concluded.
Now, when was this conversation had?
To be honest, I don't remember the exact date, but they were accepted for over 7-9 years. I don't recall the exact date.
Now, I'm not talking, so let me clarify. I'm not talking about the acceptance of the check. My question to you is, how did you communicate to Ms. Vu that these checks were for child support?
Through conversations.
Okay. And how did you have these conversations? What manner?
Through a variety of manners, direct conversations in person. I don't think a reasonable person seeing the checks and the memos as they're stated would have any misunderstanding of what the intent of those checks are for.
Now, Mr. Vu, were you responsible for paying anything else to Ms. Vu outside of child support?
There was a house for which at the time we both agreed that we would do 50% upon the sale of the house, but unfortunately the house went into foreclosure. Now the foreclosure both had an opportunity to try to take the house and take it out of foreclosure, but I had lost everything, so I could not, and I guess she did not either.
Okay, so my question to you, Mr. Vu, is Did you have any other obligations besides the child support to pay to Ms. Vu?
No, ma'am.
Remember how she said she is still making repairs to her house due to damage from Hurricane Ike, which happened all the way back in 2008? I suspect that she is actually trying to get as much money as she can from her husband for renovations to the house, not repairs, as that hurricane happened well over a decade ago.
Judge, at this time, I would like to offer State's Exhibit D, which is a proposed possession credit calculator based on the time frame of March 2011 through May 2017. And I'd like to offer that into evidence as State's Exhibit D as a guide to help the court.
Ma'am, do you have any objection to me admitting this as an aid to the court?
I don't agree with it, but I mean, he did have our son.
Ma'am, right now we're just talking about admissibility.
Oh,
Do you
okay.
have any legal
Yeah, please
objection?
admit it because I want to debunk it.
Okay.
This shows the total principal amount based on the $279.17 per month, correct?
Correct.
Okay. Now you understand that that amount did accrue interest throughout the years.
Correct.
Okay. And so the total maximum credit for possession would be the $33,186.78. You understand that?
Yes, ma'am.
And you're asking the court to award you the possession credit of this amount.
Yes, ma'am.
Do you have any questions for Mr. Vu to answer in the form of question?
Yes, he says that Nathan stayed with him until May. That is a lie.
Yes,
The reason-
ma'am, that's not a question.
Oh.
This is if you have a question you want to direct towards Mr. Vu for Mr. Vu to answer.
I have many questions.
Okay, this is your chance to ask them, ma'am.
What makes you think that you can admit that as evidence when you know the truth? Like, you can ask the counselor why I went and reported you. You kicked our son out. Why would you knowingly
Your
lie
Honor,
to
I
the court?
object relevancy. It's already been stipulated from the last hearing. She acknowledged that my son stayed with me. We can go back to the record to have that.
Sir, I'm
And
gonna, yes.
And State's gonna object to compound. If you could just break down her question.
I'm going to overrule Mr. Vu's objection, but I'm going to grant Ms. Villarreal's objection because I'm not sure what you're asking. If you can ask one question at a time, ma'am.
When did Nathan officially move out of your place?
I do not know.
Why did he move out of your place?
Yeah, ma'am, one question at a time.
I do not know the exact date, but it was somewhere in the middle of 2017.
Have you spoken to the counselor?
Objection time frame.
Ma'am, what time frame would you speak to the counselor?
Has the state received? I know I sent an email. Unfortunately, it was today from the person that Nathan was staying with back in December because we had to find housing for him.
Ma'am, this is not your chance to just talk. And when you ask questions, you often use it as a chance to get your information in, and that's not proper. So if you can stick just asking factual questions.
The statements that he's saying are false.
This is your chance, ma'am, to ask questions.
And I'm sorry, I'm nervous to ask him.
You're going to get a chance to talk yourself later, and you're going to be given a chance to be asked questions by the Assistant Attorney General.
Okay, I honestly don't want to ask him anything. Okay, I don't want to ask him anything.
Okay, I just want to make sure it's clear for the record that this is you can have other chances too, but this is your chance to ask him questions if you have any for him to answer.
Okay,
regarding the issues before me, regarding the issues in this case. Okay, this isn't a chance to just talk. If you want to do that, I can send you to a breakout room or you all can talk offline. But this is this hearing is about the issues before me that are pled for, and this is the chance for both of you to present evidence and testimony regarding this case.
I mean, I do have questions for him because I'm like, is he still a manager at his job?
Your Honor, objection relevancy.
We're discussing arrears.
No, because
ma'am, I'm going to overrule the objection.
Yes, I'm still employed at Chevron.
Okay. So your paper keeping, your records, you're trying to say that you paid me all those checks, but yet you've been a manager on LinkedIn. I pulled this up. Matt pulled this up. You've been a manager. Let's see. You've been a director of a company. You've been a manager.
Objection,
Chevron,
Your
you've been a
Honor.
manager.
Objection, Your Honor. There's no question posed to the witness.
Ma'am,
And
yeah, sustained. Ma'am,
Okay.
this is
Well-
questioned. Mhm.
Okay.
Ms. Villarreal, you may call your next witness.
thank you. I'd like to call Ms. Lauren Vu. Now, his obligation was a monthly obligation. Is that right?
Yes, ma'am.
Now, you heard, well, you saw State's Exhibit B shows that as of yesterday, Mr. Vu is in arrears for child support. Is that right? He owes.
Yes. The amount on the screen says $167,420.68. On this
That's
piece of paper that was sent in the mail says
Okay, I'm gonna object
168,000.
to the witness testifying to a document not admitted into evidence. The exhibit has already been admitted, Judge, with an updated amount.
I'm going to sustain the objection.
Thanks. Now, Ms. Vu, you could just answer my questions, okay? You heard Mr. Vu state that he paid you directly for child support, right? You heard him say that?
Yes, I heard him.
Okay.
Say it.
Now, and you saw the checks, the 8 checks in the amount of $900 that were admitted into evidence, correct? You saw them?
I saw what was on the screen, yes.
Now, ma'am, was there ever an agreement between you and Mr. Vu that he would pay you directly for child support?
No, ma'am.
Okay.
No, ma'am.
Now, those checks were in the amount of $900. Is that right?
I saw, yes.
Now, ma'am, did Mr. Vu have any other obligation to pay you a $900 per month amount for anything else other than child support?
Per month? No, he did borrow a loan, a business loan for, he called it a business loan, but he had also needed my co-signature for the beach house that we shared.
Okay.
So him.
So give me 1 second, okay, Ms. Vu. So now you mentioned a business loan. Who provided? Was there a business loan taken out?
It's from my. He did. Doug Vu took out a business loan, but he also, because he's run up his credit, I don't know what the reason was, but he had also asked my husband. Do you remember that, Doug?
Okay, Ms. Vu,
for a loan.
if you could just
Yes.
answer my questions and you're not
Okay.
addressing your comments to Mr. Vu. Now, did he borrow money from you?
He did.
Okay. What was the amount of money that he borrowed?
$25,000
Now, when did he borrow this money?
before. God, my husband would know because he borrowed it from my husband, and so that's why it's a joke.
Your Honor, objection foundation. For lack of evidence.
Overruled, but I will say, Ms. Villarreal, I'm not following a lot
Yes,
of this.
Judge.
But that's
Now, how was Mr. Vu supposed to pay back the $25,000 loan?
He said that he was going to pay us when he could, and so he paid $900 a few times. You'd have to talk to my husband. That's why I needed him to be a witness. But every time I tried to bring him here, he got shot down because it was him.
Okay.
It was Matt. It was my husband.
Ma'am,
Matt
let me stop this for a moment. I'm confused because we started this case fresh today, and you were asked if you have any
Yes.
witnesses, and you said no. No one shot you down for anything.
Yes.
I'm not sure what to do with this information.
Judge, well, I can continue to ask more questions from this party and see what other information she may know.
Your Honor, Your Honor, I object
then I will
again.
move on.
Your Honor, I object again. Foundation. This lacks any authentication whatsoever.
Okay. My objection too. I have objection too. Where did that $900 come from? Where did that amount come from? Because the divorce decree on here says the amount.
Ma'am, this is not appropriate what you're doing right now. So please calm down, take a deep breath. If you need to pause and take a break, we can take a break. But we can't just be yelling in court. And so I'm going to overrule his objection, and I'm going to hear more testimony on this. Be aware, I'm the trier of fact. I'm supposed to evaluate what I hear and receive and make my best judgment based on that. I'm trying to do that.
And just, if you could just answer my questions, were you involved in this loan transaction?
Sorry, which transaction?
The loan transaction.
The loan, okay.
No, I wasn't.
Were you aware that the $900 that Mr. Vu was providing to you were for child support payments?
No, ma'am.
Did Mr. Vu pay you anything directly for child support?
No, ma'am. No.
Now, your oldest child, Nathaniel, did reside with Mr. Vu for a period of time. Is that correct?
Yes, ma'am.
And what was that time period that he resided with him?
It was March 2011, because we were under construction at our house after Hurricane Ike.
Okay. And until when?
November, so Thanksgiving, the holiday break. And so my brother was the one that came and grabbed Nathan, and he was the one that informed me that he got kicked out of his dad's house.
Okay. Of which year?
16.
Okay, 2016,
2016.
year before Nathaniel graduated.
Yes,
that was November 2016.
November 2016, because I came to the OAG's office in 2017.
There was a calculation for possession credit for the time period of March 2011, ending in December 2016. You saw that, right? As the exhibit?
I saw that.
Okay.
And I didn't agree with December because, that was giving him more credit.
Understood. Now, at this time, I would like to offer State's Exhibit E, which is the calculation of possession credit for the time period of March 2011 through December 2016. Now, you understand that this is an amortization calculation, correct? So it includes the calculation of the interest that was accrued as well. You understand that?
Yes, ma'am.
Okay. Now, it starts March of 2011, okay? And this calculation includes the actual principal amount per month, which was the $279.17 difference per month, correct? Now, and it also calculates the interest rate that was accrued for each specific month. Do you understand that?
Understand. And
according to this calculation, based on the time frame, which is all the way through December 2016, the maximum credit is $31,218.61. Do you see that number there?
I see the number. Yeah.
Okay. Now, but your testimony is that he should not be giving credit of this December 2016.
No,
correct?
ma'am.
Because Nathaniel did not reside with Mr. Vu during that period. Okay.
Correct.
Now, so that would be that we should subtract the $397.82 from the actual total maximum credit, this $31,218.61. Correct?
Correct.
And that Mr. Vu would be entitled to possession credit for that time frame of March 2011 through November 2016. Correct?
Correct. But I'm sorry.
It's okay. Go ahead.
Okay. But I'm arguing that I took care of the children with all their medical needs, everything that they needed. And so that's why I'm like, I don't think that he deserves the relief or any of that credit.
Now,
but I mean, that's what's the court to decide. But I mean, Nathan did live with him. Nathan did live with him from March till November. I do agree with that. But giving him that, to me, I don't agree with.
She doesn't agree with giving him credit for any amount, including what he paid, because she's only interested in getting as much money out of him as possible.
Mr. Vu, do you have any questions of Ms. Johnson for her to answer?
I'm almost afraid to answer because this will just get out of hand, or ask because this will get out of hand, Your Honor. I just want to be able to enter some proof of.
Okay, this is not that time. So let's get past my first question before we go on to other things. Do you want to ask her anything?
No, ma'am.
Okay. Do you have anything further, Ms. Villarreal?
No, Judge.
Okay. Since you're both representing yourselves, I'm going to give you both a chance to say anything else you'd like to say. The state does not represent either of you. I don't represent anybody in this. I'm here to listen to evidence, a ruling. So I'm going to let you speak. I just want to remind you all, this is court. Please follow court decorum as you would in a courthouse, even though you're on a computer. This is a courtroom. And please remember to stick to the issues that are before us, which is a confirmation of arrears. Mr. Vu, I'll let you go first.
Well, yeah, Your Honor, I just want to just acknowledge the evidence that I put forward. I just want to acknowledge that there are arrears that I did owe, but they're not the amounts. I want to acknowledge that we've accepted the possession credit. I want to acknowledge that the reasonableness clause to be able to state that, given those payments that I made that clearly show they were intended for child support payments, and the fact that they were accepted by her acknowledges those were child support payments. I want to acknowledge that. That's it, Your Honor. That's it. Thank you.
Thank you. Ms. Johnson, is there anything else you'd like to say?
I want to say that what he has, it says on there that that he put into evidence back in 2017. He had all this time to prove that he paid me those. That was 2017 when I went to report him. He had all this time. Where is the evidence? The last OAG's lawyer said that he had to provide 104 checks. Where's that proof? I don't know how am I supposed to defend something that doesn't exist? I'm just trying to show a pattern of deceit and lies with this person. I was told recently that if I just found out, I didn't know, but if he got another job and he made more money, was he not supposed to report that? I don't know if that's true or not. Was he supposed to report that? Can the court answer that to me?
I cannot answer that question, ma'am. It's not relevant to this proceeding. I can't. I'm not here to just answer. I can't give legal advice, and it's not my place, especially something that is not relevant to this current proceeding before me. It's inappropriate for me to be advising you.
Okay, well, what I'm stating is that he's been hiding assets ever since we divorced. When we were together, he was hiding assets, and after he was hiding assets, he had another restaurant called Cafe Madrid. If you look it up, you can't find it. But if you go online and you put in Cafe Madrid, because I just found it, I went and scouring the internet for it. I couldn't find it, but then when I scoured the internet and put in key information because he was in the paper.
Your Honor, at this time, I am going to object to relevance and narrative.
Well, it's a pattern. It's a pattern, and he was supposed to report his earnings or his job, correct? Like if he was to get another job.
Judge, may I get a ruling on my objection?
I'm going to sustain the objection. Please try to stick to relevant issues.
Now let's watch her absolutely lose it when she realizes she isn't getting her way. And pay close attention to her facial expressions as she realizes she isn't getting the $170,000.
It was contentious. I was kicked out of my beach house. When we were living
that is not what I asked. I'm asking the dates, approximate, and I understand you don't have a date, but I'm asking time frame for the loan that you're talking about.
2000.
And you don't have to, I'm asking you to perjure yourself. Again, pre-divorce, post-divorce would answer my question. Ma'am, are there any documents?
I'm going to find a piece of paper with your handwriting, with your handwriting on it.
Ma'am, that's not appropriate. You're not supposed to be having a conversation with Mr. Vu. So please stop doing that. Okay, I was asking a question before you interrupted me, Ms. Johnson. Do you have any documents regarding the loan?
Not with me, ma'am. I'd have to find it.
Do they exist?
It exists. Oh, it exists, but we're still under construction. I mean, it's in a box. I'd have to find it.
Okay. Was the loan addressed in your divorce?
No.
Do you know what he was supposed to pay towards you said that it was what he could afford.
He had several things going on at once. He had Cafe Madrid. He had.
Your Honor, again, objection, relevancy.
Ma'am, what's the relevance of that? Ma'am, why is that relevant?
It's relevant because I think that he thinks that by giving me $900 that he's applying it to the child support, which we never agreed on. And where did that amount come from?
Okay, what does Cafe Madrid have to do with any of this?
Oh, it's yet another asset that he was trying to hide from me.
Okay, I'm going to sustain his objection.
And I didn't know about it.
Ma'am, I'm going to sustain his objection. Okay. Does anyone have anything further? Any further evidence you'd wish to present?
I would like the court to honor what was on the divorce decree. I mean, it was his lawyer and he that drew up the amount, and it was he that said that he was going to honor it, and he did not. Everything that's on that the divorce decree, he has not honored, and that's why I'm bringing up the beach house and the restaurant, and this because it's a history, it's a pattern. It's a pattern. Ask him about what happened to the restaurant.
Your Honor, again, objection relevancy.
Ask him what happened to the beach house. I didn't
And
have any
objection,
say
Your
in
Honor,
any of that
outside the
stuff.
scope of this proceeding.
I'm going to sustain both objections.
The only pattern here is you making a claim and trying to back it up with something that has nothing to do with the claim, and then having outbursts when you don't get your way.
You're back on the record. Okay, I've looked at everything and reviewed everything. So I am going to give possession credits in the amount of $30,820.79. And that is the full amount less the full amount per exhibit. I'm sorry. Per exhibit E, which is her proposed periods of possession less that last column. And then I am going to also give some credit for direct payments and order a cumulative child support judgment against Mr. Vu in the amount of $75,000 as of, I guess, March 20th of 2024.
Yes, Judge.
In terms of a payout, I don't believe I ever heard how much is in the retirement account or how much approximately.
Yes, Judge, for this amount, for a judgment of $75,000, Judge, the arrears alone is $375. I'm sorry, the interest.
Yeah.
I'm sorry. Yes, the interest alone is $375 per month. State is just requesting that it cover the interest and an additional amount, so that it can cover that.
He was currently paying twice a month. It's just twice a month, $359.23.
Yes, Judge. It's about $718.46.
Why don't we set the payout then at $700 a month?
Yes, Your Honor.
I'm sorry, Your Honor, my dog was. I didn't hear that last amount about.
I'm sorry, I couldn't hear you.
Yeah, I can. I
sorry.
can. You can't hear me.
No.
One more time. Can you hear me?
Yes, but sometimes it breaks up, so I don't know if it's going to break up again until you start speaking.
Okay, I'm sorry. I didn't understand the $700 amount that you were talking about.
It's a monthly amount you're going to pay off that judgment.
Okay.
And then it will change though, because, well, it won't change, but it will go down faster because the quadro is going to be entered. I have no idea how much is in that account. So I don't know if it's going to pay it in full. And once it's paid, you won't owe that anymore. Or if there's going to be money left over. I don't know.
Okay.
Right.
So can I ask a process question? So the quadro will sweep the account for $75,000. Is that what that means?
I don't know what's in the account, so I don't know. I don't know how much money is in the account, so I can't. If there's only $5 in the account, it's not going to take 75,000, and I don't know the number. I don't think it's 5, but I don't know if it's 75,000 either.
Yeah, but if there is that amount, then what is the $700 a month for?
Because if there is only $5 in the account, you're going to have to pay this back.
I understand. Okay.
So it's not going to take. It's all the state can take from you. Not really taking from you, all that they can withhold or that you will owe, because it might not, you might have to voluntarily pay this depending upon your job. All you would owe would be to pay off the 75,000 plus any interest that accrues on it, because it will accrue interest for the family code 6% per annum.
Yes, Judge.
And that 700 will begin April 1st of 2024. And as I said, the judgment is as of March 20th. And then I'm going to order that Mr. Vu pay any court costs due to Galveston County for the motion to confirm arrears by September 30th,
How much
2024.
is the court? I'm sorry. How much is the court cost?
I don't have an exact number for you, sir. It's usually a few $100s. Just depends on the filing fee and service fees and what service did or didn't happen in the case. So
Yes, ma'am.
And Judge, you said September 30th of 2024, correct?
yes.
Thank you, Your Honor.
And how will I be notified of that cost?
You should probably contact the district clerk's office in Galveston.
May I appeal this?
Yes, you may, ma'am.
I'm appealing it.
Okay, that you might want to consult a lawyer or the law library or texaslawhelp.com.
No, I will get a lawyer. I'm letting Doug know.
Ma'am,
I'm
saying it on the record, I just want this clear on the record. Saying you appeal it on the record does not appeal it. I just want you to know that. So you might want to consult a lawyer.
Thank you, Your Honor. And with that, Your Honor, may the parties be excused to the breakout room so they can prepare a final order on this case.
Yes, you all may be excused to the breakout rooms. The AG's office is going to draft the order. It is a ruling of me, so if you refuse to sign, I will be signing it anyway. One moment, ma'am. And yes, so in case you didn't hear that, you're going to go to the breakout rooms. Miss Villarreal is going to draft the order. She'll send it to you through DocuSign to review and sign off on. If you refuse to sign, that's fine. Signing it doesn't mean you agree, just so you know that. If you refuse to sign, that's fine, because it was a ruling of the court. I will sign the order. Ms. Johnson, are you okay?
Stormed off because she didn't get her way. Classic. If you enjoyed this video, I promise you'll enjoy this next video. I will see you there.